for bill introductions from the committee. I know Representative Goddard has one.
Thank you, Mr. Chair. This is RS 0724, and it's the school bus arm bill that has been through committee before. It got to the floor, but never came above the line.
Any questions? Any objection? We will get that one introduced. Any other requests from the committee? What about our visitors today out in the gallery? Any requests? Come on up.
Yes, my name is Colin Olnick, and on behalf of the Self-Advocate Coalition of Kansas and the Disability Rights Center, I would like to introduce Bill 687, creating the Supported Decision Making Agreement Act.
Very good. Committee, any questions? Any objection? We will get that requested. Thanks for coming. Anyone else today? Not seeing any. We will move on to our first bill hearing. We don't have minutes, do we, Kathy? That's not on the agenda. Did you not send out an email that we were going to have agendas or minutes to review? Okay, maybe I'm just imagining that. So let's do our first bill hearing. I'll open the hearing on House Bill 2065, and we'll have Natalie come up and give us an overview.
Thank you, Mr. Chairman. House Bill 2065 allows the court to change a spouse's name to a name other than a maiden name or former name during a divorce proceeding. Current law in KSA 23-2716 requires the court to order the restoration of a spouse's maiden name or former name at the request of the spouse during the course of a divorce proceeding. This bill would allow the court to order a spouse's name be changed to a name that's different than their former or maiden name. And I can take any questions.
Representative Carmichael.
Thank you. Ms. Scott, was this bill at one time known as HB 2474 in 2022 and passed out of this committee but failed to rise above the line?
Yes, that is correct.
One more substantive question. In the text of the bill, it indicates that one spouse may petition or request the change of name of such spouse. And the phrase such, the word such appears in a couple of more instances. I interpret that to mean that if I'm involved in a divorce with my spouse, which by the way, we have had one, and I did not insist that she change her name, which saved us money later on because we didn't have to buy new checks when we got married again. I interpret that to mean that if I'm in a divorce proceeding and I want to change my name, that I can have my name changed, but she, the other spouse, could not force me to change my name because it looks to me only the party whose name is to be changed has the standing or the ability to request the change. Am I interpreting that correctly?
Mr. Chairman, Representative Carmichael, I believe you're interpreting this provision of law correctly, which says, upon the request of a spouse, the court shall order the restoration of that spouse's maiden name or former name. So I think the spouse wanting the name change has to be the one making the request. I don't know if there's a different prohibition, say in your settlement agreement that requires, a spouse to change their name back or something like that. But I think you're reading this provision.
And that's actually beyond the scope of my question. I just want to make sure that I can't force my soon-to-be ex-spouse to go by trout fishing in America or some name that I would like her to be known as. Thank you.
Any other questions for Natalie? Okay. Thank you, Natalie. Proponents, we have one. Is she on WebEx? There we go. Judge, are you on WebEx with us?
I am on WebEx with you.
Perfect. There we go. Good to see you.
Good to see you again.
You're up. Take it away.
Okay, thank you, Chairman Patton, for having me again. I have appeared, this is my third time appearing before the members of the House Judiciary Committee, and thank you for allowing me to come again. Ms. Nelson just succinctly wrapped up exactly what this statute would allow, which is that any person, the husband or the wife, who wishes to have a name change as part of the divorce could petition for that request or orally move at the end of the hearing to make such a request for a name change. I would point out to the committee members that this statute is very old in that it still refers to a woman's birth name as her maiden name, which I think is extremely archaic language. And if the statute is amended, I would request that that be, that maiden be stricken and that birth name be the substitute. I think there's another way to describe that too. Maybe a original name, I don't know, but that would, I think, would be important. The reason I have advocated for this bill is I have had a number of cases come before me where I believed that the petitioner or the party asking for a name change has had a very good reason to ask for a name other than the name with which he or she was born or the name of their, actually it would be their first spouse, and this is their divorce from the second spouse. That's the first instance that comes to my mind where you would have a former name. I also think this should be unisex, that either party can ask for a name change in a divorce. What I put in my written testimony is the one case that really caused me to think about this, in that I had a woman appearing before me who was divorcing her husband, who was in prison for sexually molesting their children. When I asked her if she wanted a name change, she said that she wanted to change her name to her mother's birth name. And I said, well, I didn't think that I knew that wasn't provided for in the statute. And did she have any other name that she would ask for? And she says, well, I don't want my birth name because my dad beat and sexually molested me. So that is not a name that causes that would I want associated with my first name. She obviously wasn't real thrilled about keeping her second husband's name, but that's what she ended up doing. And we have a separate procedure where a party can come back years after the divorce has been granted and ask for a name change. And I keep thinking of this woman that if we can have this statute amended, she could come back and have her name changed to that of her mother's maiden name. I also know that there have been concerns in the past concerning the lack of publication, and that a party may be trying to circumvent the normal name change petition requirements, and would be changing a name for purposes of fraud to avoid creditors, any number of other nefarious reasons. However, I would point out that when a divorce is filed, generally that request for the name change is made in the petition. It is sent to the opposing party, who would be the first person who would be pointing out, I believe this person is doing this in order to perpetrate a fraud upon creditors, the banking system, some other entity. And additionally, in divorces, one of the filings that is also required is what is known as a domestic relations affidavit. And in that domestic relations affidavit, the parties set out their creditors and their assets, but particularly their creditors and how much is owed to each and every creditor. And that is a public record. It's part of the court filings. And I think that in and of itself is actually more revealing than a person filing for a name change who simply swears, I'm not doing this in order to perpetrate a fraud. So for all those reasons, I don't think that there is any reason that nefarious things could occur by allowing persons to change their names to anything that they wish. With one caveat, the judge still has final control or say over that request for a name change. And my latest story with doing divorces and a name change is I did have a young woman, when I said, do you want to change your name? And she says, well, yes, I really would like to change my name. And I said, and what's your request? And she says, I now want to go by Danger Mouse. And when I asked her if that was the name with which she was born or was a former name, and she said no, I said, even if you could change it to Danger Mouse just because you wanted to, I wouldn't do that. So, as I said, the judge can be a gatekeeper against a misuse of this process. Are there any questions?
Any questions, committee? Representative Carmichael, or Representative, let's go Representative Heiberger first.
Thank you, Mr. Chair, and thank you, Judge, for being here for the third time. Hopefully, as they say, the third time is the charm. If that's the case. I had a case like this last year, and it was in front of your court, and you didn't know it because we didn't ask. But I represented the petitioner. The respondent wanted a name change to something other than the respondent's former name, and is it so? So we didn't ask for that. So if that person wants a name change now, there's going to have to be a separate petition filed. There will be publication fees. And is it fair to say that if you rank all the filing fee, the publication fee, and the lawyer's fee together, it could end up costing that person $1,000 or more? Does that sound accurate?
That does sound accurate. And I would point out to the committee too that I need to get the percentage, but a large percentage of the people who file for divorce after filing a poverty affidavit and setting forth to the judge why they can't pay the almost $200 filing fee. And I have granted 99.9% of those requests to file and waive the filing fee because they are telling me the truth. They simply don't have even the $200 in order to proceed with the divorce, much less $1,000 or more to do a petition for a name change.
Representative Carmichael.
Thank you, Mr. Chair. And following up on my friend from Lawrence's excellent question, Judge, even in the presence of a poverty affidavit, on a standard name change proceeding, there's still the expense of publication, which can't be waived or avoided, I don't believe, by a poverty affidavit, can
it? As far as I know, it cannot, because
right.
The newspaper
It deserves to get paid.
Right, the newspaper wants to get paid.
Well, I've done tens, if not hundreds of these for legal aid, and my clients have had to pay publication charges, even though the lawyer is free, and even though we would use sometimes poverty affidavits. If I could, though, let me turn to the use of the word maiden, which I believe ought to be out of our statutes. I take it, I'm looking at it because we use the phrase in both the law as it stands now, as well as the amended language. We use the phrase such spouse's maiden or former name. If we made it just prior or previous or former name, or would we be okay to just use former name? Or do you have suggestion based on your experience as to what language we ought to employ so as not to refer to maids, maidens, and I don't know what the male equivalent might be?
I don't think there is a male equivalent. It's only those of the gentler sex that have such things attached to us. I Yeah, just former name. Well, should be good.
That seemed okay to me too, but I'm sure that our reviser can look for other statutory conflicts and perhaps prepare us a balloon amendment to accomplish that worthwhile task. My final question, Mr. Chair, with your permission, of course, is the same question in essence that I had for the reviser some moments ago about, I hope you were able to hear that interchange, were you, Your Honor? Before you testified, were you able to hear the questions that we had with the reviser?
Yes, trout fishing in America question?
Yes.
Yes.
My old friend Trout Fishing in America gets mentioned every time we hear this bill. It's just
Yes.
remarkable. But the substantive question, though, as you interpret this language and the use of the phrase, such person may petition upon the request of a spouse, the court may order such spouse's name to be changed. It looks to me like that if I'm in a divorce, I can petition to have my name changed, but I don't believe I could force my soon-to-be ex-spouse to take a different name. Is that the reason I say that is we have some written testimony that might question that, but do you interpret it just means that I can change my name, she can change her name, but I can't change her name against her will?
That's exactly how I interpret that.
And
yes.
I do as well, and that certainly would be my intent. Thank you. I appreciate it, Judge. Hopefully we'll get it done this time.
Thank you very much.
Representative Goddard.
Thank you, Mr. Chair. I hope this is an easy one. I agree with the idea of former name, but what about current? Former or current name?
Well, if that's your current name, I don't think you'd have to change it.
But if you don't want to go by that name anymore and you want to change your current name to some other, former and current, would that be appropriate language?
Well, maybe I don't have the proposed statute right in front of me, but it's the request to change a name. So I don't know that you'd be changing your current name. You would just, to your current name, you would be changing how you appear in the pleadings, which is your current name, to either a former name or another name of your choosing would be the options.
Maybe we should say just change your name and don't reference former or current.
That sounds very rational and reasonable to me.
Thank you. I just like to keep things simple.
Yeah.
Any other questions? Okay, thank you, Judge.
Okay, thank you.
Yes, good to see you. We have written proponent testimony from Joe Molina. Joe's here today. He's shaking his head. It's written. He's not going to testify. Anyone else here as a proponent? Do we have any neutrals or opponents? Seeing any, we'll close the hearing on House Bill 2065, open the hearing on House Bill 2129, and have Natalie come back up.
Thank you, Mr. Chairman. House Bill 2129 requires defendants who petition the court for forensic DNA testing to notify the court when that testing is complete and to request a hearing based on whether the evidence is favorable or unfavorable. Section 1 amends KSA 2125-12. That's the statute related to forensic DNA testing. Current law there authorizes a person in state custody who is convicted of first-degree murder or rape to petition for testing of certain biological samples. This bill amends subsection A there to allow a person in state custody after sentencing for aggravated criminal sodomy to petition for that testing. Subsection F is amended to require the petitioner within 180 days after the conclusion of testing that is ordered to notify the court that DNA testing is complete and claim whether the results are inconclusive, favorable, or unfavorable to the petitioner. If the petitioner claims the results are unfavorable, Current law requires the court to dismiss the petition, and they may assess attorney fees. This bill doesn't change that process if those results are determined to be unfavorable. If the petition claims the results are inconclusive or favorable, and they are of such materiality that a reasonable probability exists that the new evidence would result in a different outcome at trial or sentencing, or there is a substantial question of innocence, then the court shall order a hearing, and if the petitioner proves that claim by a preponderance of the evidence, then the court shall enter an order that serves the interest of justice. The bill also adds a new paragraph 4 to provide that if the petitioner fails to notify the court within 180 days after the conclusion of all DNA testing, then the court shall dismiss the petition. And subsection H is added to provide that it's the intent of the legislature that the amendments made to this section are procedural in nature and shall be construed and applied retroactively to any currently pending petition. And I can take any questions.
Any questions for Natalie? Representative Lewis.
So if I understand, I mean, I take it today, any good defense lawyer is going to have the DNA testing done at the time. So is this primarily designed to be retroactive, to go back to convictions that were obtained, in the day?
Mr. Chairman, I think maybe what happens is someone is currently in custody because they've been convicted of one of these crimes. There might be new evidence, DNA evidence, that suggests someone else committed the crime. So the defendant wants it tested while they're in custody because they've already been convicted.
I see. Thank you.
Any other questions? Thank you, Natalie. Proponents, we have Aaron Breitenbach on WebEx.
Yes, thank you, Chairman, and thank you to everyone else for allowing me to be here remotely today. Greatly appreciate that. Just to start off, perhaps by addressing that last question, most often these are not situations of new evidence. New evidence can be handled through another statute that addresses what to do in case of new evidence. This is more often applied where someone has been convicted and one of two things: either evidence was tested at the time, but perhaps technology has improved to, where there's an argument that retesting could be of value, or it's quite common that biological evidence or potential biological evidence is collected from all kinds of places throughout a case. As law enforcement, as prosecutors, we tend to narrow the focus of what's actually examined in a lab for DNA versus just what's swabbed and collected at various places. And that winnowing, and the defense can sometimes request things be tested as well pre-conviction. But ultimately, after a conviction, a defendant may say, well, these other things that you didn't test, I now want those tested. And that's where the statute comes in. And it works, or it can work, to make sure that winnowing that occurred at the trial level was correct. And in cases where it wasn't, maybe further retesting or testing would be helpful. Unfortunately, though, there are a lot of cases that we're seeing where the winnowing was correct, where analyzing swabs that were collected from locations or surfaces that really have no bearing on the alleged crime, it doesn't serve any justice serve any purpose other than taking up the time of a DNA analyst, candidly. And that is a finite resource in this state, not just in Central County, but statewide through the KBI and Johnson County at their locations. So this bill seeks to make sure that if we're going to peel back the onion and take up an analyst's time, that there is some modicum of the determination, or the court having an opportunity to determine, is this something that really might make a difference? I give in my written testimony the example that in many sexual assault cases, the defense is consent. Well, there's nothing that a DNA test is going to give you that's going to shed light whether consent was or was not given. Nevertheless, case law has made it difficult for courts to keep out these requests. And basically, well, if it could shed light on something, we have to give it. As recently as this last September, the gatekeeping provision of this statute was largely made meaningless by preventing courts from doing any kind of weighing or any type of determination of the merit of what could be obtained through the testing. So again, the purpose of the bill is to empower courts to serve the function that the original statute, I think, intended, which is to be a gatekeeper, to make sure that tests that could bear fruit are greenlit and that those resources are made available to make sure that no one is improperly convicted or remains in custody. But then also maybe winnow out those requests that really are not going to serve any purpose other than to take up someone's time. I mean, sadly, a lot of these folks are serving very, very long sentences. I say sadly for them. And they don't have much else to do other than make requests like this. Our courts do have other things to do. Our DNA analysts do have other things to do. And so we need to free those resources to make sure that they're best serving current defendants so that their cases can be heard, their samples can be tested, and that justice can be brought more swiftly for both victims and defendants going forward. With that, I'll defer to any questions that the committee may have. Thank you very much.
Questions, committee? Representative Carmichael.
Thank you, Mr. Chair. A couple of questions for you, Mr. Breitenbach. My compliments on the beard, by the way.
Yeah, this was a holiday COVID experiment that's run amok.
Well, when I looked up, I didn't recognize you. And by the way, I appreciate the help that you've been to the committee over several years. You and I just may have to disagree on this one.
That's fair.
Do I understand, though, that this procedure and this legislation only applies to first-degree murder and rape presently under the law, and this would expand that to aggravated criminal sodomy as well? So is it only 3 specific offenses that we are talking about?
At this, yes, that is correct.
And so in Sedgwick County, say over the past 4 or 5 years, given the very limited application of this law, how many times has the KBI lab been called upon to do the DNA testing under the present regimen? Because I'm concerned about overloading the KBI lab, of course.
Sure. I can't speak to the KBI. We tend to use the Forensic Science Center.
I apologize. Modify my question accordingly.
Sure. I can give you that number offline. I don't have it handy. I probably should have. That's an excellent question.
Is it a handful or is it 1,000?
It's not 1,000. I don't mean to suggest that it is, but it's more than a handful, and it's the type of thing that, for example, these hearings also often take up an analyst's time to come to court just to discuss whether or not, the test has merit, so to speak, and that may be unavoidable, and that's fine, but the way the statute has been interpreted, the court, even when they receive that testimony, says, well, I have an analyst telling me this isn't going to make any difference, but I still have to order it. And that just can't be, that can't be what was intended, because the statute, as it's written, suggests and actually states that the court should, make some determination of the probative nature. And so what we're trying to do is really clarify what we believe was the original legislative intent, which is to reserve those analysts' time to the cases that would be most likely to bear fruit. And I guess I would put it this way.
Okay.
I'm sorry.
I just want to try to get in the rest of my questions before the chair cuts me off. Go ahead. I apologize, Aaron. I interrupted you. I'm sorry.
No, and I appreciate that. I just let's say that it's 2. Let's say that only 2 requests are done, right? And one of those people tragically is truly innocent and the other is not. The processing of that other request unnecessarily, by definition, will delay justice for the innocent person, right? So kind of making it as...
No, I don't agree with I don't agree with that is right.
Okay. All right, fair enough.
I would like to avail myself, however, of your offer for that information. If you can find a convenient time frame and let the chairman know, and then perhaps he'll share it with the rest of us as he might deem appropriate. Mr. Chair, though, there is one other substantive area I'd like to explore, if I might. In the testimony of the opponents, they seem to uniformly raise objection to the use of the phrase material to the prosecution. And I think their argument generally is that the prosecution already has its evidence, and the evidence material to the prosecution's evidence is already known. That what we're talking about here is exculpatory evidence that needs to be tested because there may have been a terrible miscarriage of justice. Why do you seek to limit the ability to do DNA testing only to evidence which was material to the state's prosecution, but is apparently not limited to exculpatory evidence, which might be, well, the evidence that exonerates a defendant?
Well, I think we have to look at how that term is used in this statute. Clearly, it's the prosecution that convicted the person, right? It's not the defense that convicted the person. So anything that's material to what got the person convicted is what we're looking at. If it's something, now, to your point, if it's something that is material, so I guess as used in this situation, prosecution doesn't mean district attorney or county attorney. It means the case that got the person convicted. So there's the investigation, what police department does, and then there's the prosecution, the criminal case that resulted in a conviction. So, you know, if maybe replacing prosecution with, you know, criminal case that resulted in conviction, I suppose. But that's how that term is being used here, and that's how it's written originally. I understand material is being added, but what it's saying is material to the case that resulted in a conviction.
Sadly, I don't think that's what the black letter says. Thank you, Mr. Chair.
Additional questions? Representative Munn.
Thank you, Mr. Chairman. Aaron, nice to see you. So my understanding is that these modifications, and correct me if I'm wrong, are basically to address the way the courts have been handling this. First of all, on the criminal sodomy, I believe there's a Kansas Supreme Court case, at least one, that specifically included aggravated criminal sodomy into this statute, and now we're just codifying that. Is that correct on that front?
There is as I understand, there is a case that basically because the conduct is the same, it's just a different parts of the body involved, and so on a due process argument, it has been included through case law, and so we are codifying that. But it also makes sense. I mean, that's one area where we believe it would make sense to include that provision.
I guess I only knew that because I did the appeal on that case. But no, I don't. But the second thing, my understanding was that the courts were acting as a gatekeeper anyway to these type of motions, and I've litigated many motions and done appeals on any motions. Has there been a change in the way the appellate courts have been addressing this, where they've kind of opened the door and closed the door on the open the door to the defendants, but closed the door on the trial judges as a gatekeeper on this?
I believe so, and in my written testimony, I cite State v. Angelo that came out the end of September this past year, that again precludes any type of pre-weighing or really, and I understand the concept. It's hard for you can't have the verdict before the evidence is in, but there are times, again, like in a consent case or others, where without weighing the strength of the evidence, someone should be able to say, even if this says what you say it says or could say, it doesn't change the material facts of the case, such as you confess to having sex with the person, so therefore, you know, some other person's DNA, you know, being present doesn't change the fact that you acknowledge having sex. You dispute the lack of consent in that act, but it doesn't change the material fact that was the basis of the conviction. But it's not just that case. I mean, going back to pulling up a case here, Bruner v. State from back in 2004. So shortly after this, one of the early iterations of the state, there was language that recognized that To try to quote here, these provisions might allow a fishing expedition, which we must conclude is one that the legislature has concluded is worth conducting. And so that kind of language undercuts the court's belief that there is a gatekeeping function, despite what I would say is present in the statute, I believe in subsection C, which asks or directs the court, one, to determine some amount of relevance, and then two, could an answer make a difference? And that second question in C, as recently as last September, has been largely eviscerated.
Thank you, sir.
Other questions? Okay. Thank you. Are there any other proponents? Now we will move on to opponents. Clayton Perkins is first.
Thank you, Chairman and members of the committee. I'm Clayton Perkins, Chief Attorney at the Capitol Appellate Defender Office and co-chair of the BIDS Legislative Committee. We are here in opposition to this bill. And I think I'll start with another quote from the Kansas Supreme Court on the way this statute has worked and has been in effect for over 20 years. And that is that the statute is laudable yet limited. This is a remedy for wrongful convictions and for people who are needing to prove their actual innocence to be able to get testing that hasn't occurred or could help to prove their innocence. And it's within a limited scope of cases: first-degree murder, rape. I think State v. Denny, the case involving equal protection and ag-crim sodomy, is still good law. But one of the realities with the Kansas Supreme Court's precedent on this line of cases is that actually 10 years ago, you could get more tested under this statute than you can today. The State v. Denny case was based on equal protection principles that expanded access to DNA, post-conviction DNA testing a little bit. Cases like second-degree murder, which are extremely similar to first-degree murder, might have been able to get post-conviction DNA testing from that. But the Kansas Supreme Court over the last several years has actually overruled that line of precedent and has significantly even narrowed the scope. So the sort of general idea that the Kansas Supreme Court has been broadly expanding this, I think, is something that I personally disagree with. And I think even the State v. Angelo case is one that is in line with the way this statute has been interpreted for the last 20 years and was the original legislative intent, which is that when there is evidence that hasn't been tested or could be tested in a way that provides new information that is exculpatory, that is going to be tested. And then once it's tested, the courts are going to evaluate that evidence in addition to the evidence of conviction after the testing has occurred and determine whether and what happens to the case after that. The idea of this statute is to get evidence tested so that for people who are wrongfully convicted, we can get that information. And indeed, in cases where they were correctly convicted, then we have that assurance that testing was available and we already checked those boxes. And I'm actually going to read just briefly from the State v. Angelo opinion. This is paragraph 5 of the syllabus that defines exculpatory in this context, because again, to get testing done, there needs to be both biological samples available and also that it may be exculpatory. And evidence is exculpatory when it tends to disprove a fact and issue which is material to guilt or punishment. Determining whether evidence is exculpatory under KSA 21-25-12C is not a function of weighing the evidence. It is enough that the evidence tends to establish a criminal defendant's innocence, even if it does so by only the smallest margin. And I think that's the correct test under this statute, that it is the testing can result in evidence establishing innocence. And I don't think we want to add more barriers to that level of to that type of testing. And this statute does this this bill would do this in a number of different ways. There's the materiality component, which would limit it to just the prosecution's evidence when I know there are other speakers here who are also subject matter experts who might be able to further provide examples of this, but the materiality limitation would mean that we're focused only on the evidence showing guilt and was used to convict, whereas the evidence that ultimately exonerates is often overlooked during the original prosecution. There's a change that would limit this to post-sentencing as opposed to post-conviction, which would just delay this process even further, which is unnecessary. There aren't that many cases, I will say, where you realize a wrongful conviction has happened in the time before sentencing has happened, but it does occur. Most recently in Douglas County, a former defendant was just added to the National Registry of Exonerations in a case where it was actually recognized that they were wrongfully convicted almost immediately after conviction happened, and issues of ineffective assistance of counsel were then raised in post-conviction motions for new trial. So there are cases where that's identified and can be timely raised, even in those confines. And I'll also just briefly mention the other aspect of this sort of threshold determination, because this adds both the materiality component, but there's also that language touching on that the judge will do a totality of the evidence style review prior to DNA testing being done. And while I am certainly sympathetic to lab personnel being overworked, the component of a judge doing a complete review of the factual circumstances of a conviction, which might be a week-long trial, just to address a preliminary issue of whether testing can occur, that's also a significant burden. And I think the fiscal note kind of plays that out, that it would create a significant judicial burden at the outset of testing, when really just getting the DNA testing done is the first step to look at the case. And I am happy to answer questions at the appropriate time, but I know Professor Phillips is here as well and is probably better at answering the question.
Very good. Well, then we'll have Professor Phillips come up next, and then we'll do questions for both of you at the same time.
Thank you, Chairman and members of the committee. My name is Jean Phillips. I am a professor at KU Law School. I am the director of the Project for Innocence. I want to make it very clear, I am not here on behalf of the law school or KU. I am here in my individual capacity, having dealt with a number of clients who have been convicted, and then we've used DNA to exonerate them. I'm also here on behalf of the Kansas Association of Criminal Defense Attorneys, who asked me to speak as their liaison. There are a number of things that I'd like to chat with you about today. I'm going to try to keep this brief, however. The reality is that according to studies as recently as 2018, 6% of state populations are innocent, 6% of the population. In Kansas, we have over 10,000 people incarcerated. That's over 600 people who are incarcerated who could potentially be innocent. That's not counting those that are convicted, or limiting it just to those convicted of first-degree murder or of rape or egg sodomy. That's just sort of across the board, because there are lots of ways people can establish innocence besides DNA. So we're limiting that even a little bit more here in Kansas. But what I would encourage you to think about is that wrongful convictions are one of the evils we should be fighting against, right? You're upending people's lives. You're throwing someone in jail for a crime that they didn't commit. That affects families, that affects children, it affects them, it affects us as a society. And I would encourage you not to try to limit that, but to try and make sure that we guarantee this doesn't happen. I appreciate what Mr. Breitenbach said, that in Sedgwick County, they tried to winnow out and decide what pieces of evidence are important. But what we're talking about for a lot of these people is not current prosecutions that are happening, but there are older prosecutions, right? There are people who were convicted 10 or 15 years ago before the Sedgwick County started winnowing out of their cases. So I want you to sort of keep in mind that there were lots of instances where individuals did not have the benefit of perhaps Mr. Breitenbach. I also want to sort of just remind you, and maybe this is being a little patronizing, but words matter, and changing even the slightest words are going to matter. And the Kansas Supreme Court, the Kansas Court of Appeals are now going to have to try to decide, what did we mean when we said material to the prosecution? Did we mean material to everything that entailed in the prosecution of that individual, or did we mean what was admitted as evidence at trial? And so words matter, and we need to be really careful when we start tinkering with words. So there are a number of things that I want to address. I'm going to limit it to 3 things that I think are substantive and 1 that is more time sensitive. So the first one that was actually raised here, I think, by Representative Carmichael, that the testing is limited to those instances where DNA is related to the investigation with the addition of the language and is material to the prosecution. I'm thinking about Floyd Bledsoe, our office representative Floyd Bledsoe, and perhaps you are familiar with him. He was convicted of the rape and murder of his sister-in-law. It ended up being that it was his brother who committed the offense. When we started that case and we did the DNA testing in that case, none of the evidence that we tested was in any way material to the prosecution. They weren't looking at the clothing of the victim that we found that was still in the dump. They weren't looking at the bodily fluids that were obtained. They weren't looking at any of that. It was not material to the prosecution. And under this particular version of the statute, unless that language is clarified a great deal, which I suggest doesn't even really need to be there, I think if it's part of the investigation, that's sufficient. That encompasses all of Mr. Breitenbach's concerns. We wouldn't have been able to test in Mr. Bledsoe's case. He would still be incarcerated. Right? That's the problem when we start tinkering with language. There is in his written testimony, Mr. Breitenbach didn't talk about it today, but in his written testimony, he wants to get rid of the word more accurate and probative results to just say probative results and get rid of accuracy. And he says, because it doesn't matter whether it's 1 in 6 or 1 in 800 sextillion, it's still going to be. That misunderstands how DNA works. When we first started doing DNA testing under PCR testing, they had kits, and the kits would look at 13 genetic markers. And those are markers that tend to be very discrete, right? They're not checking for hair color or eye color. They're checking for discreteness, things that would really differentiate you from me. And it was 13, and it might be 1 in 6tillion. But then they changed it, and it's now 1 in 18. And it might still be 1 in 6tillion, but now they're checking for 23 markers. And all it takes is one marker to not be there, and you have excluded somebody. So maybe the first 20 did say that this individual matched, but it didn't match on 22, and it didn't match on 23. We should always be able to go back for more accurate results. And that's something we should all strive for. I want to talk a little bit about under subsection C. Mr. Breitenbach talked a little bit about this, about having to review a totality of the available evidence before the court decides whether or not to even grant testing. Essentially, if you look at testing statutes across the nation, they're divided basically into 2 different types of testing statutes. One requires you to look at evidence before testing, and the other requires you look at evidence after testing. Kansas is one of those states where we look at evidence after testing, and that was a very deliberate choice by the legislature, and one I encourage you to keep. If you look at a review of the available evidence, you are not going to allow, there's chances that individuals would not be allowed to have testing, right? The whole point of DNA testing is that it lies outside of what's available. It's new and it's different. And the statute already says exculpatory, right? The court already has the ability to say if it's going to produce non-cumulative and exculpatory evidence, then you get testing. But if it's not exculpatory, you don't. I find it really hard to believe that courts are going to say in sex cases where the individual is saying, she consented to the sex, Now, the court's going to find that testing the semen is going to somehow come up with exculpatory evidence, right? That's the kind of case that is exactly going to be excluded. I would be very interested in the number of cases where that actually happens, because in my experience, that's not the kind of cases that are going before the court. Now, I granted that I'm not all seeing and I don't know all cases, but that's not been my experience, and I've been doing this for 30 years. I would ask you to look at State versus Angelo. State versus Angelo says that you have to, if you pre-weigh the evidence, that's a problem because you don't know. In Mr. Bledsoe's case, you could have knocked me over with a feather when we got the evidence back that said it was the father who was a part of that crime. You could have knocked me over with a feather. The father testified at trial on behalf of his son, Tom, right? He sort of sacrificed Floyd for Tom. And we now know why, because his evidence was all over the victim's clothing. We would have never known that if we would have had to meet these standards. We would have never understood what actually happened. I also want to talk about the 180 days. Well, actually, one more thing before we get there about the standards and the heightened standards. On page 2, line 29, it now would read, the amendments would read that the petitioner would have to prove by a preponderance of the evidence that it serves the interest of justice, and then you could get vacating a sentence or discharge or resentencing or a new trial. Here's the problem with preponderance of the evidence. That is a standard that the U.S. Supreme Court has already said is too high for most post-conviction cases. It is too high for ineffective assistance of counsel. All you have to prove for ineffective assistance of counsel is a reasonable probability of a different result. And in Jackson versus Holland, the U.S. Supreme Court has said that is something less than a preponderance, because a preponderance means you have to show it's more likely than not. You have to show 51% chance or 60% chance, right? We shouldn't be requiring people to not get any sort of hearing or relief just because they can't meet that standard. Reasonable probability is sufficient. I want to sort of end by talking about the 180 days. I understand that you don't want cases to go on in perpetuity. I get that. But one of the things that happens with DNA evidence, especially for cases that are old, 10, 15 years old, and we're going back and testing the evidence, is it changes dramatically the position of that case, right? Again, going back to Floyd Bledsoe, could have knocked me over with a feather about the father. That changed everything. It changed how we looked at the evidence. It changed how we had to investigate. And it required us to take a step back and to go back and to do further investigation. And sometimes that further investigation can take longer than 6 months. It takes time to do all of that, to locate the witnesses, to find them, right? And so I would encourage you not to limit to 180 days from the time that testing ends, because there are times when you need to do additional investigation based upon the results that you get, right? In Floyd's case, testing opened the door. It wasn't the end of the process. We had to do further investigation. And again, I'm just going to close by saying the whole point of this statute is to correct those wrongs. Prosecutors are fallible, juries are fallible, we're all fallible. But if there is a wrong that's happened, that individual deserves their freedom. We should be striving to correct that and not to limit and increase the barriers and the hurdles. I stand open for questions.
Questions, committee? Representative Lewis.
Thank you, Mr. Chairman. Thank you. Early in your testimony, you cited some sort of study that said that 6% of what convicted.
Yes, that's 6% of the prison population, right? And that's not 6% of the murderers or 6% of people convicted of rape. That's 6% of the prison population. And they base that, that could be someone with burglary or whatever based, because it's not always DNA evidence that it gets people out. Yeah.
So, and who did that study?
That study was done through the Innocence Project, and in my testimony, the written testimony, there's a footnote there that leads you to the site. So if you go to the Innocence Project, there was a university that undertook through the National Exoneration Center and examined all of the different ways that people, right, can be found innocent, and sort of made some extrapolations to that's kind of the general. They admit that there could be margins of error. But the point is that even, right, 5 people, 6 people, 10 people, 20 people is too many.
Thank you, Mr. Chairman. Am I pronouncing this case right? Bloodsoe?
Mm-hmm.
Yeah. What was the defense in that case?
There wasn't much of a defense in that case, actually, other than he didn't do it, right? There was not a lot of investigation. The trial attorney didn't do a lot in terms of trying to figure out what happened, and nobody was really paying attention to what happened. He just made an argument and tried to poke holes in the state's case, saying that it wasn't Floyd, it couldn't have been Floyd, it couldn't have been Floyd. But that wasn't sufficient.
So why wouldn't why wouldn't the DNA testing that was requested be material to a case where the defense was he didn't do it?
It is material to the investigation. My concern is the way that statute is, the language is written now is material to the prosecution. Are they going to interpret that to mean that it is material to the evidence that was actually presented? Because nobody bothered to look at the clothing on the victim. That wasn't an issue. It wasn't an issue about whether or not there were bodily fluids. There was never an issue about whether or not she was raped or not. And most of the testimony was based upon that she had been drugged and that her clothing was up above. And so that would sort of support that there had been a sexual assault. The state's case was based upon the testimony of Tom and the testimony of Tom's parents. And the defense's case was based upon trying to poke holes in that testimony. There was not even a thought about going out and doing the rest of that investigation. And my concern by saying that it's material to the prosecution, are we saying that it's material to what was presented at trial? Or are we saying, as Mr. Breitenbach suggested, that it's broader than that? It's not just the state's case, but it's what led to that conviction. If it's what led to that conviction, I think that is met by the language is a part of the investigation.
Thank you.
Representative Schreiber.
Thank you, Mr. Chairman, and thank you for testimony. This might be for anyone that has testified so far, but all of you have kind of stated that the availability of DNA testing labs may be insufficient or create a backlog for testing in the state. I'm just curious how many there are in the state and what the general time frame is for running a sample and the throughput of those labs on a daily or weekly basis, if you know.
Well, I don't know the throughput on a daily or weekly basis. I do know that, there's the KBI lab, there's the Sedgwick County Forensic Lab, the Johnson County has a forensic lab. Kansas City Police Department actually has a forensic lab that's willing to do stuff on, if we send it there, we have to pay for it, but they are willing to do stuff. Most of our cases, we have the good fortune of working with the Midwest Innocence Project, and they have funding sources, and we send our cases out. So we'll send them out to Serological Institute in California or to Bodie on the East Coast. So we don't always use the labs here, but I do know that if you use the labs here, it takes longer to get your test results back.
And long meaning?
It can take up to months to get your test results back, 6, 7, 8 months to get your test results back.
As opposed to out of state is?
So when we go to Siri, it usually takes us about 3 months to get out. So it's not a huge difference, but it is a difference. And I don't know what the Sedgwick County lab schedule is. I don't know how backup they are in Sedgwick County or Johnson County. I just know about like the KBI when we use KBI.
And they all do the 22 or 23 markers?
I believe that the KBI now does the 23 markers. I know that Siri and Bodie do the 23 markers. I believe the KBI does. I have to tell you, I don't know because we don't really use Johnson or Sedgwick, so I don't know what their labs use.
Thank you. Thank you, Mr. Chairman.
Further questions? Representative Carmichael.
Thank you, Mr. Chair. I might suggest that if Mr. Breitenbach is still available, he might be able to give us a slightly different perspective on DNA testing, what's available, how long it takes, how many markers, if someone would like to inquire of him. And then I have other questions.
Representative Schreiber.
To defer to me, boy, pretty special. So is Mr. Breitenbach still on?
Yes, I am. Thank you. I can confirm what Professor Phillips has said, and I have to acknowledge I just spoke with Professor Phillips last week and appreciate seeing her again here today. So,
Good to see you,
um,
Aaron.
in any event, not on this, but anyway, I can confirm, yeah, that 6 to 8 months is probably about what Sedgwick County is as far as the number of markers. That sounds right. It's in the low 20s, so that sounds about right. Um, and as I've already offered to provide some numbers, at least to Sedgwick County, and I'll see what I can from the other labs, the number of these tests that are done under this statute. I'll also try to get some other just background information on how long tests take, how many, these questions are being asked. I'll see if I can get some of that information gathered into the committee in short order.
Thank you. Thank you, Mr. Chairman.
Representative Carmichael.
Thank you. And by the way, Mr. Breitenbach has been a big help on all kinds of issues before this committee. And I'm sorry that today is the day that he and I happen to see an issue a little differently. And I see Ms. Phillips.
It's been a big help to me on occasion as well. So.
Yeah, Aaron Breitenbach
yes.
Aaron Breitenbach is a fine lawyer. That being said, there's a doctrine of the law somewhere, and I can't quote it in Latin, but I think it generally says that the legislature is presumed to know what it's doing, and that when they make a change in the law, it's presumed that they did that for some reason, that it wasn't just to keep Ms. Scott busy in the evenings, but rather we really intended to change the law. So I would like to share with you from page 1, line 19, the existing law, I believe, reads, is related to the investigation or prosecution that resulted in the conviction. Under this bill, though, we are making what I believe to be a substantive and material change, and it would instead say is related to the investigation and, not disjunctive, but and material to the prosecution that resulted in the conviction. Can you try to address that from the standpoint of the presumption that when we change words here, we intend to do something different? And in particular, the use not only of material, but the use of the word and as opposed to the disjunctive or. What's the impact of that?
So I tried to allude to that a little bit in what I submitted for written testimony, and that is that words do matter. And when you change it from related to the investigation or the prosecution that resulted in conviction, and you make it related to the investigation and the prosecution, you have now heightened the burden. And adding the word material to the prosecution heightens it even more. I mean, it depends upon the context in which you're talking about materiality, but in terms of exculpatory evidence, it's substantial likelihood of a different result. And now we're changing that. And material can have that kind of a heightened standard. And that's not what what I believe should be the focus when we're deciding whether or not to even grant testing. Because again, you don't know what you're going to get. That's the whole point of testing, is that you believe that there might be something else out there and you're trying to establish innocence by testing. So if it's related to the investigation and the prosecution, which maybe goes to Representative Lewis's question, that would cover all of those issues about, right, if it's related to the investigation or the prosecution. Yeah, whether or not the clothing would come back with any sort of DNA or the bodily fluids would come back with any sort of DNA would be related to that, and it would be related to the prosecution. The question is, what does the word material and material? So it's related to the investigation and it's material to the prosecution. That just doesn't mean that it's evidence presented, it's material to the prosecution, and it's the word material that bothers me the most, because that word, at least in the US constitutional jurisprudence, which is what our courts generally go to, has a heightened burden, right? And that worries me when you're right on the front end of trying to decide whether or not to even grant testing.
And if I may, a second area, Mr. Chairman, I think it ought to be evident, but way I understand it is, if we put an innocent man or woman in jail, absent a suicide, like has happened in some of these cases, what that really means is the person that did it is still at large to
Yes.
murder, rape, and sodomize again. So if we're concerned about justice from your perspective, why wouldn't we want to use a broad brush and incur perhaps a little bit of extra time or delay or expense so that we can find out who really did it and put the murderer or the rapist in prison, or in our state, even on death row?
So I know that Tricia Bushnell from the Midwest Innocence Project couldn't be here today, but in her written testimony, she talks about Mr. Fry, who she had represented, and he was wrongfully convicted, and it took retesting of the evidence for more accurate results. And then it took 6 or 7 more months of investigation before they were able to establish that the person who, when they finally ran the testing through CODIS, which is the national lab or national database for data sequencing, it popped back with a hit on the person who actually committed the crime. And then they contacted that person, they did further investigation, and that person confessed to the crime. And in the meantime, between that person being arrested, between the time the crime occurred for which her client was convicted and the time that the other individual who actually committed the crime was arrested, he had committed additional rapes, including those of children, right? We have a real obligation to make sure that we've got the right person. And if that requires some resources that we use of the state to make sure that we have the right person, that's what we should be doing, right? For our sake, as well as the sake of the individual who's wrongfully incarcerated.
And finally, Mr. Chairman, if our purpose here is justice, and our purpose is to protect the public from the perpetrator remaining at large and victimizing others, would it make sense to perhaps expand the scope of the testing to second-degree murder, manslaughter, felony murder, aggravated battery, aggravated kidnapping, so that we can do more justice in this state instead of less?
So I am not opposed to expanding the number of crimes that are encompassed underneath the statute. I will say that, going to Representative Lewis's question about the 6%, that 6% is not limited to just the rapes and the murders, right? That includes the kidnappings, that includes other kinds of crimes. And if you think about that, in robberies, we now have DNA that touch DNA, right? You will find my DNA there because the friction, and I left behind my epithelial cells, my DNA is there. So if you grab someone's clothes when you kidnap them, if you grab something when you rob them, that DNA is there. And so you can do a lot more DNA testing in crimes other than, when the statute was created 20 years ago, we were thinking seminal fluid, right? So we were thinking rape and murder, because you might have blood, saliva, seminal fluid, that sort of thing would be there. But we now know that we can test. That's how we found Floyd's father. It's because his DNA was all over her socks when he drug her to the garbage dump and buried her, right? So it's all, DNA is changing. And so that 6% does encompass a whole lot more crimes. And I would suggest that if we're truly interested, we might want to expand that.
Yes, Representative Mott.
I'm just, in your experience looking at these type of cases, has it been your experiences that the district courts are just either summarily denying or approving these sort of requests, or are they having hearings? I mean, that's on whether or not to proceed with the DNA testing.
So in the cases that we work on, or that we work on with the Midwest Innocence Project, we always draft pretty detailed motions because we try to meet that it's non-cumulative and it's exculpatory, and there's a reason that it's going to be material to the investigation and you should take a look at it. And so we draft pretty detailed motions, and then there's always a hearing, right, where the judge makes a determination about whether or not we met the non-cumulative exculpatory evidence that would justify having DNA testing. And I will say, in some instances, we don't even get pushback. right? We've had instances where actually Sedgwick County, it wasn't Mr. Breitenbach, but Sedgwick County said, yeah, we don't oppose that. We'll sign an order, right? And we both, it's submitted and we both agree to it and the judge issues the order. So sometimes, but again, we're proving it up on paper as best as we can. And sometimes we do have to fight it before we actually get a hearing, but we don't have to go back and say, let's weigh it against the evidence that exists because we don't know what the DNA is going to tell us yet.
Okay, so what I'm hearing is that the courts generally do
Yes.
look at this.
Yes, it's not automatic. I don't just get a court saying, yeah,
Or no, right?
Right. I haven't had a court say no to me yet.
And the ones that might get a summary disposition of some sort are generally pro se motions from the prison that are generally.
Yes, I do know that there are pro se motions where they have been denied.
Right.
Yeah.
Representative Smith.
Thank you, Mr. Chair. And I think my question is for Mr. Brian Bach, if he's still on. And it's to the point that Ms. Phillips points on line 19, page 1, is related to the investigation and material to the prosecution that resulted in the conviction. I read through that like 5 times before I finally come to the idea that, you know, when you do a crime scene investigation, you're oftentimes swabbing things, powdering things, looking in all types of places, just in case you don't have the theory of the crime right? So it could have occurred in these rooms, it could have occurred in this room, or as in a case I had where a child told us that it occurred in a vehicle, dad's vehicle. So we think we have the vehicles there, and in fact, it turns out to be another vehicle. But here now we have a whole box full of DNA swabs of several vehicles that it did not occur in, because that was in our search warrant. Does it become then useless to send all those back through DNA testing because they were a part of the investigation, but they were not material to the prosecution? And I think that was the way I took it when I read it first. Is that correct?
I just briefly, yes, that's yours. You did a better job than I did in explaining that language. So thank you for that, Representative Smith.
Other questions? Yes, Representative Osman.
Thank you, Mr. Chairman. Are you able to speak on the advances in technology as to DNA testing over the last 20 years?
Yes, I can. I don't want to get bogged down in like a 2-hour lecture on DNA, but when DNA first came out, which actually one of the very first cases that went up was a Kansas case, State versus Gonzalez. And we had what we called RFLP testing, and it took an enormous amount of biological material, and it wasn't incredibly discrete. And they didn't have great data banks, right? They didn't have a great way to compare it. Technology has come a long way because as you enter more and more, it's sort of like the chatbot stuff that's going on right now, right? The more you enter into the computer, the better the computer is at spitting stuff back out at you. That's sort of the same thing that's happening here. The more DNA data that gets entered into the CODIS database, the more discrete the testing can be because you can compare it across broader. We now have what we call PCR testing, which is polyisomer chain reaction testing, where they can take very, very small amounts of DNA and they can replicate it to create a larger amount of DNA. And they look for, again, those very specific genetic markers that are more discrete. So they're not looking for brown hair, blue eyes, or green eyes. They're looking for things that are really discrete, like DS2243. And don't ask me what that means, but it's a very discrete DNA marker. And they used to look at, we had cases way back in the day, like in the early 90s, where they were looking at 7 to 10 markers. And then they went to 13 markers. And then they went to 15 markers. And you have to remember that just one marker can exclude you. You and I might have every single marker be the same except one. And that means that you and I are not the same person. And so the more markers you get, the more discrete the test gets, the easier it is to exclude people. We also have better ways of testing. Back in the day, if you've ever seen the they look like little x-rays with bubbles that go all across. They were trying to is it a gray, is it a light gray, is it a dark, and it was harder to discern. Now we have electropherograms, and they just bump up and they tell us more discreetly if that, whether or not that person has a particular genetic marker. It's not having to read weird x-rays. You're reading a graph basically. And so it's much more discreet now.
All right, thank you. So as I understand it then, based on what you're telling me, and as I read through the bill itself, there could be a case from, say, 20 years ago where the prosecution has done all the DNA testing that they wish to, and the defense has also done all the DNA testing that they wish to, that today or 5 years in the future, there might be some DNA testing that would exonerate that person.
Yes.
And that would be barred under this proposed legislation.
Well, I am not sure if it would be barred. When I read this, it says retesting with new DNA techniques that provide a reasonable likelihood of more probative results rather than more accurate and probative. I'm not really sure why to get rid of the word accurate, because it seems to me the more accurate you are, the better it is. It's not just probative, but it's more accurate. So I don't know if it would get rid of testing, right? Because you could still retest if it's probative. But again, I'm going back to my concern that I put in my written testimony that words matter. And I don't know why you change words or delete words. I'm worried about the impact that that's going to have by the Kansas courts to say, well, now it has to be something else because why did they get rid of the word accurate? And I think accuracy, that's what we should all be striving for, not just probative, but accurate.
Any other questions, committee? Thank you.
Thank you.
Committee, we do have written opponent testimony from the Midwest Innocence Project, so make sure to read that over. Any other opponents? Okay, I'll close the hearing on House Bill 2129. Committee, that is it for today. I am going to rattle off a list of bills that we may work later in the week. Say may. I think some of these might have some amendments, so we'll see where we're at with them. But 2010, 2023, 2027, 2028, and let's add 2065 from today to that list as well. I'll go over those again tomorrow as the week moves forward. Likely not going to get to them until Thursday, but we'll see where we're at with things and maybe do an easy one on Wednesday if we have time, but likely not until Thursday. So that's it for today. Everybody have a good evening. We're adjourned.